biosecurity determination simply says that this version of the declaration is the individual declares they've got a medical contraindication to COVID-19 vaccines and I quote, can produce evidence provided by a medical practitioner of that matter. The reason why this is important, Your Honour, is this. Can I take Your Honour back to Annexure A, which was part of Section 119 notice? So Attachment A, Your Honour, the next page, which was really part of Attachment A, was what is entitled Biosecurity Act 2015 reference.
Yes, indeed.
That's a misnomer, but we don't take anything from that criticism. It's not a reference from the Biosecurity Act. It's a reference from the Biosecurity Entry Requirements, Human Coronavirus with Pandemic Potential Determination 2021. The relevant point is that the only bit of that determination that is extracted there is an extract from Section 5, Sub 3 of the determination. That, in other words, is the part of the determination that, read with Sub 2, requires a declaration of status, in effect. And that declaration of status was made. Mr. Djoković made a declaration that he had a medical contraindication. He was not required, as part of that declaration, to provide evidence, even though, as a matter of fact, he did. So
Mr. Wood, at some stage, you may wish to make some submissions expanding upon the questions of construction or the proper approach to construction of these sorts of determinations. Both council have addressed in broad compass, on a reasonable assumption, settled principles respecting the proper construction of, and I emphasise this for you, in order, legislation, and then secondly, regulations, and then thirdly, subordinate regulations, and perhaps fourthly, a determination of this kind, and it may have particular status that I need to have my attention drawn to, but there seems to be a point, perhaps two, at which the approach taken, if you will, to legislation stands in contrast with the more practical approach to be taken to the consideration of subordinate legislation. The authorities contain some suggestion that choose workplace regulations. They're to be understood by the people on the shop floor. Contrastingly, you've got a determination which finds its genesis in a Biosecurity Act. And it just preoccupied me a little, because your primary submission is that there is no relevant requirement. And you put that challenge front and centre at the feet of the respondent. And part of this that is perhaps of assistance in trying to think it through is perhaps through Section 499 of the Act, with which you're all well familiar, but in terms, the Migration Act confers power for the Minister to give written directions. And you see that all the time. Every week, people come in and my attention is drawn to these documents, PAM, and I think IMMI documents, and subsection 499(2)A effectively provides expressly that a person or a body must comply with the direction under subsection 1. Now, I know that this is a point that lies sort of in parallel or in tandem with your threshold issue, but one way of reflecting on this problem that's arisen in this case is the well-worn idea that if the Parliament, as it's often said, had wanted something to be a requirement, it would have said so. if there was to be regulation saying you must do X, the regulation would say so. Now, these biosecurity determinations have some sort of status here, but they don't have the status of a 499 type direction. Have I got that much right?
Can I make a few responses, Your Honour? For a start, I understand when Your Honour refers to 499 of the Migration Act, Your Honour might do that by way of useful analogy in terms of an appreciation of the type of approach one takes to instruments or directions issued under 499. Of course, nothing's been issued under 499 that matters here. Okay.
I agree.
Yes. The second point I would make is that the instrument issued under the Biosecurity Act, so this is the biosecurity determination, carries criminal consequences for breach. That flows from section 46 of the Biosecurity Act itself. And I'll just read it out. Your Honour may not have it before you. So,
can you give me a minute, please? Please go on.
So section 46 sub 1, Your Honour, of the Biosecurity Act,
yes,
says an individual to whom a requirement determined under section 44 brackets entry requirements applies must comply, civil penalty and so forth.
Yes.
The biosecurity determination that we're concerned with, Your Honour, was made under section 44 of the Act. So as a starting proposition, one would construe it in accordance with the usual principles strictly. In any event, one would expect quite clear expression of exactly what is required and what is not.
Well, again, the force of that submission wouldn't it, be magnified by the express provision of civil penalties, which perhaps someone like Mr. Holdenson might immediately. I'm now having real.
I'm hearing an echo, Your Honour.
I'll put it briefly. It might have been the point that penalty units were not a very large amount, but 30 penalty units for a contravention of this type of requirement would again magnify the importance of strict compliance.
Absolutely. Now, can I make my third point in response to Your Honour's question?
I'm sorry to take your time up.
No. I just signal at the outset, Your Honour, I absolutely appreciate the time limits Your Honour has imposed. I do want to assist you with answering questions. It only helps my client and it can only help Your Honour. If I feel I want to ask for an extension at the end of my submissions, I may do so, but we'll cross that bridge when we get to it.
Yes, and it won't be a bridge you need worry about until about 1:45 p.m.
Thank you very much, Your Honour. So can I explain this, Your Honour? Can we come back to section 5 of the biosecurity determination?
Yes.
Can Your Honour look at subsection 2? Recalling that the extract given in the notice under 119 was of subsection 3, which intersects with subsection 2, right? Now look at subsection 2. It says the individual must be able to produce to a relevant official evidence that before the individual boarded the aircraft, right? So this is in Dubai, in Mr. Djokovic's case. Before Mr. Djokovic boarded that aircraft, he made a written statement that included a declaration mentioned in sub 3. Then you go to sub 3. And that requirement of the content of the declaration is effectively a declaration as to whether or not the traveller fits in within category A, category B, or category C. And that declaration was made. And Mr. Djokovic said, I fit into category B. I have a medical contraindication to COVID-19 vaccines. The point that is of relevance to ground 1D, which is simple and for myself, I cannot understand how it can be answered, is that B2 says, 3B2 says the individual can produce evidence provided by a medical practitioner. It is plainly not required at this stage of the process. In other words, while before the traveller has boarded the aircraft, to produce the evidence. He simply has to declare that he can do so.
Again, pausing there, Mr. Wood, when we get to about 4 a.m. and travel through to about 6:30 a.m. on the morning of last Thursday, the transcript is replete with statements by Mr. Djoković saying, if you will let me talk to people, although you've taken my phone from me, I will try and get you what you want.
Indeed, Your Honour. Beyond that, in a sense, there's a degree of artificiality or mootness to this whole discussion, because not only was Mr. Djoković doing his level best to provide to the officer at Tullamarine everything that he wanted, and did indeed provide material to that officer, but Mr. Djoković, and I'll come to this in due course,
sure,
did indeed provide that material, that evidence from medical practitioners before he boarded the aircraft. Now, but park that for a moment. I just want to be as clear as I can about the point we're trying to make here on it. Now, if we can go back to the biosecurity determination, we've talked about sub 2 and sub 3. Can I take Your Honour to sub 7?
Yes.
A distinct requirement. It says, if a relevant official asks the individual to do so, the individual must produce, and then go here relevantly to B, if the declaration included the individual's statement was of the kind mentioned in 3B, which is the case here, the evidence mentioned in subparagraph 3B2. So it's a very clear and distinct process. You make the declaration before you board the aircraft. You say, I declare my status, unvaccinated, medical contraindication, and you declare that you can produce the evidence. Later, only if you're asked, under sub 7, do you have to provide it, the evidence. Now, the point that matters here, Your Honour, is come back to attachment A, recall the function of the section 119 notice of which attachment A was part. Your Honour will recall that under the Act, and the cases are crystal clear about this, the decision maker, in advance of making the decision, must provide particulars of the grounds. The only relevant particular that was provided here, so far as it relates to the biosecurity determination, was section 5, sub 3, not sub 7. So Mr. Djoković was never even notified, as he would patently be required, if indeed later the decision maker was to decide that there was a ground flowing from something else. But he was never notified under the 119 notice that he had breached sub 7 by failing to, quote, produce evidence relating to his declaration on request. He was only ever notified of a particular of the proposed ground of cancellation, implicitly that he had not complied with section 5, sub 3. But that obligation was only to make a declaration, not to provide evidence.
I understand it.
Thank you. So, Your Honour would probably appreciate, therefore, why this, yet again, not to undercut its significance, but legally is a very simple point. Let's come back to part B of the decision record, which sets out the reasons, or more precisely, details of the evidence and findings. We were looking at paragraph 2, and I make the point that the middle sentence, in context, has to be read in light of the section 119 notice that cited only section 5 sub 3 and not section 5 sub 7, can only be understood in context as suggesting that the declaration that is required to be given under sub 3 must be accompanied by evidence of the medical contraindication, manifestly incorrect at law. Now, beyond that, Your Honour, skip over the remainder of that paragraph and skip over the next one for a moment and come to the fourth paragraph that says, all visa holders, whether permanent or temporary, are expected to abide by all public health directives issued by both Commonwealth and state and territory jurisdictions. A breach of these directions is considered a potential risk to the health. A breach.
Sorry,
should I proceed, Your Honour?
No, you should not. The court will adjourn briefly.
The Federal Circuit and Family Court of Australia stands temporarily adjourned.
Okay, guys, we're just waiting for the court to start again. The judge has just asked for a temporary pause, and you can see the lawyers from both sides waiting for him to return. So that's where it's at. This is live. It's happening right now in Melbourne, Australia, Federal Court of Australia. This is to do with Djoković and his appeal against the removal of his visa by the Australian government. And if I may add my own comment, I think it's absolutely disgusting the manner in which Djoković has been treated. Here we go. We're back again.
Open the court.
Silence. The Federal Circuit and Family Court of Australia is now in session, recalling the matter of Novak Djoković, the Minister for Home Affairs, for hearing.
Please continue, Mr. Wood.
Thank you, Your Honour. We were looking at paragraph 4 of point 7, and I read it out to Your Honour. That the substance of it is it says, all visa holders expected to comply with public health directives issued by various jurisdictions. A breach is considered a potential risk to the health, safety or good order of the Australian community. That paragraph can only sensibly have been included in this part of the document, which invites, quote, details of the evidence and findings about why the delegate is satisfied the grounds exist, particularly in light of the statement in the final paragraph, based on the above information I am satisfied. It can only sensibly be understood as forming part of the delegate's reasons for why Mr. Djoković was considered to be a potential risk for the health, safety or good order of the Australian community. The only legislative provision that might be capable of being characterised as a public health directive issued by any of the relevant governments is that which was identified in the section 119 notice, and that is section 5 sub 3. It is manifestly not the case that Mr. Djoković breached section 5 sub 3 of the biosecurity determination, and any conclusion to the contrary is clearly erroneous. What Mr. Tran and Ms. Wooden submit, Your Honour, is that one is to, in effect, generously read point 7 and assume that what the delegate is speaking of is section 5 sub 7. That submission cannot be accepted for two obvious reasons. Number one, as I've been at some pains to try to explain, section 5 sub 7 was not particularised as a basis upon which the ground for cancellation existed in the section 119 notice. So if it is now sought to be reconstructed as, in effect, what the delegate meant, then one would have the clearest jurisdictional error imaginable, which would be a finding that a ground exists based on a matter that hadn't been the subject of the section 119 notice, which required particulars of the basis upon which the delegate appeared to think the ground existed, just QED. In any event, Your Honour, it would be erroneous because Mr. Djoković did provide evidence both before boarding and after arriving at Tullamarine of the matter. Now, can I take Your Honour to an important piece of evidence? Can I take Your Honour to Bannister Affidavit number 4?
Yes.
Bear with me. Bannister Affidavit number 4, in the body of it, records, and I won't bore Your Honour by going through all of the email chains, but in substance records the fact that Ms Bannister continually asked AGS, I'm not being critical of AGS, but we kept making requests as soon as this situation emerged on the early hours of Thursday morning for the material before the decision maker and what was on the records of the department. What ultimately came back relevantly to this point is the document at page 35 of the affidavit.
Yes.
It has the heading ATD for Novak Djoković.
Yes.
Oh, here's TK. We're in.
Can I ask whoever is on screen to make sure they mute themselves? There is every importance that the only people who should be online with their microphones are those who are making submissions to the court. Any other behaviour by any person who may be wishing to watch this live will produce a very real risk that the bandwidth available for this hearing will be overwhelmed and the hearing will be interrupted, and that is utterly unacceptable. Please continue.
Thank you, Your Honour. So if Your Honour is at page 35, you'll see that document is headed ATD, which can be taken as meaning Australian Travel Declaration for
Yes.
Novak Djoković. This is the document that was completed by Mr Djoković or his agent before his arrival in Australia. It was the form prepared by the government to facilitate compliance with Section 5, Sub 3 of the Biosecurity Determination. If we turn the page to page 36, you'll see question 9. It says, please provide your vaccination status, and therefore a series of boxes are provided, yes or no, that enable a traveller to comply with the requirement in Section 5.3 by making the requisite declaration. And Your Honour will see 9.1.1, again, part of the form, says, I declare I cannot be vaccinated for medical reasons. I'll come back to this document in relation to a later ground, but for present purposes, Your Honour will see that the box yes is ticked. The declaration, therefore, is made. Moreover, 9.1.1.1 says upload proof that you are unable to be vaccinated for medical reasons. And indeed, as I'll seek to demonstrate to Your Honour later, that proof was indeed uploaded. What was uploaded was the medical exemption document that had come from the Chief Medical Officer of Tennis Australia that recorded...
Can I ask you to pause here, because it's a matter that has really preoccupied me. The status attaching to this medical exemption the applicant in this case, as with perhaps the vast majority of persons who may be seeking Mr Wood to enter with a valid travel permit, together with, if it was the fact, a medical exemption rather than a vaccination, can be assumed not to be a specialist medical practitioner. But the whole structure of these contemplated arrangements is that one would go elsewhere to a medical practitioner to obtain the exemption. It would be, you'd think, absurd that a person could issue the medical exemption for themselves. And by extension, the evidence in this case serves to underline what seems a relatively significant fact, particularly in the context of cancellation of a visa once a person has arrived, that here a professor and an eminently qualified physician have produced and provided to the applicant a medical exemption. Now, further to that, that medical exemption and the basis on which it was given was separately given by a further independent expert specialist panel established by the Victorian State Government. And that document was in the hands of the delegate. And the point I'm somewhat agitated about is, what more could this man have done?
I agree, Your Honour. Can I make a global observation about what happened at the interview? I won't go into detail for a moment, but I will in due course. What emerges with utmost clarity from a review of the transcript of the interviews that Mr Djoković was subjected to at the airport, combined with his own affidavit describing interactions with officers when the tape was off, was a repeated appeal to the officers with which he was dealing that, to his understanding, uncontradicted, he had done absolutely everything that he understood was required in order for him to enter Australia. He had engaged with Tennis Australia. They had facilitated, or that they had received his application for an exemption. That application for an exemption had been assessed by that eminent, the eminent members of the two panels to which Your Honour has referred. A document that is of great significance to another ground that I'm going to come to in a moment, Your Honour, is not only that, but observe the moment that this is the declaration being made under Section 5.3. Observe that he did, so this is before boarding the aircraft, attach evidence in support of the declaration that he made, being the medical exemption certificate, which one sees on the very next page, page 37. You see the top medical exemption certificate attached. So this is the document that was uploaded with his declaration, and therefore, in advance, Mr. Djoković provided the evidence that any evidence that might have been required, even though Section 5.3 did not require it to be done at that point in time. And it said what it said. So I will come in due course to a later document that was issued by the federal government, which is of great significance to another ground. But just so Your Honour can see where this fits into the context, the later document came from the federal government, from the Department of Home Affairs indeed, the substance of which was saying, in response to the declaration made here and the attached medical exemption certificate, that his declaration had been, quote, assessed, and that document was clearly capable of being understood and was understood by Mr. Djoković as meaning that the federal government thought he was okay to come.
Pointing here, this is not unimportant. The process of assessment raises the anterior question of assessment by whom. And the reason I put it in that context to you, Mr. Wood, is that the transcript is replete with a sort of back and forth about what's been given by the federal government, what's been given by the state government, what's been given by Tennis Australia. And Mr. Djoković is quite candid. He says, look, if I've got these facts wrong, I'm sorry I'm mistaken about it, but I understand I've given you everything that you want. And in effect, I wouldn't have even come here unless you had. Indeed, and more than that, this is the point that I'm asking you to assist me with. The assessment of the travel permit or declaration is only an assessment by a federal body.
Correct. Can I take Your Honour to that document? Because I think it assists in light of what we've been discussing, Your Honour. So can I take Your Honour to the assessment? We've looked at the actual declaration made, which is relevant.
Make sure you get it on the transcript for the page and reference, please.
Yes. Can I take Your Honour now to the first Bannister affidavit? That's where I find the assessment document. And it is Annexure G to the affidavit of Natalie Bannister made on the 6th of January.
Thank you very much.
Now, Your Honour will see there is large bold text with the Commonwealth crest. It says Australian Government, underline, Department of Home Affairs. Then says, Dear, redacted, we have received your Australia Travel Declaration, in other words, ATD, as referred to in the previous document that we were looking at, on 1 January 2022 at a certain time. Then it says status, bold. Then it says bold type. Your Australia Travel Declaration has been assessed. Underneath that, it says in non-bold, your responses indicate that you meet the requirements for a quarantine-free arrival into Australia where permitted by the jurisdiction of your arrival, referring relevantly there here to Victoria. No problem with Victoria. So take a step back. Mr. Djoković has made the declaration required under Section 5.3. He's provided evidence in support of that declaration, even though it wasn't required by the instrument at that point in time. Then what happens is, after making that declaration, he or his agent receives from the Department of Home Affairs, being the department that assists the respondent to this proceeding, a document that says your Australia Travel Declaration has been assessed, and your responses, which must necessarily include the evidence that he uploaded in support of that declaration, being the medical exemption certificate from the CMO of Tennis Australia that referred to the eminent medical practitioners and recorded what it recorded, your responses indicate you meet the requirements for quarantine-free travel. Now, what is someone in Mr. Djokovic's position supposed to understand? Any reasonable person would understand, and he did understand, that he had ticked absolutely every box. Now, all of this, Your Honour, to put it in context, is highly relevant to the grounds that we advance about the exercise or purported exercise of discretion, if indeed a discretion was enlivened here by the delegate to cancel his visa. Let me just put it in a summary so everyone understands the point. Even if the 119 notice was valid, it wasn't. Even if it was open to the delegate to be lawfully satisfied that Mr. Djokovic is or may be or would or might be a risk to the health of the Australian community, that then opened up a broad spectrum discretion about whether or not, notwithstanding the state of satisfaction, the visa should in fact be cancelled. And what Your Honour was putting to me a moment ago is that the overwhelming impression that is formed on reading the transcript is that Mr. Djokovic in the early hours of Thursday morning was continually saying, I'm utterly confused in substance. I've done everything that's been asked from me. And in particular, and I'll take you on to the transcript references in a moment, kept referring back to the very fact that he'd got this assessment document from the Department of Home Affairs, which says what it says. And he was saying, if there's been an error, I don't understand what it is. I would like some time to speak to lawyers in Tennis Australia and so forth, which time was denied. That's the subject of a different complaint.
Well, I'm sorry. I thought on a view of the case being advanced and the evidence in the transcript, it's not a case of time being denied. It's, in fact, objectively, broadly, an agreement to give time, which is then reneged upon.
Correct.
So the relevant idea, if you will, you know, in the waking hours of Thursday morning, 4 a.m., a person is instructed apparently asking for instructions, what do I do next? I think if you would let me have enough time so that when Tennis Australia is awake, when my agent is awake, and when I'm able to communicate with them by telephone, in a meaningful way, take up the opportunity which is embodied in this invitation to provide you with anything further you might want. But what happens is something completely different.
And indeed for him to even understand what on earth was going on, given all that he'd received back from both Tennis Australia representing what the product of the independent panel was, but moreover, and importantly, the document that came from the Department of Home Affairs itself, which indicated that his ATD, which included the exemption certificate that he passed on, uploaded, had been assessed.
Do you understand it is any part of the respondent's case that when your client said, for example, at transcript page 23, line 30, I would like to postpone it to 8:30 if possible, comma, yes, that being but one of the requests he made throughout the night?
I agree.
The delegate said, no, that's not on. Wasn't the burden of the exchange with the relevant delegate on a fair reading of the whole of the transcript, yes, you can, until it was recanted at the point when the cancellation decision was given to him?
Yes, and can I add two things by way of...
But does that overstate the position, or do you think that's accurate?
I think it's accurate. And what I wanted to do was to augment it by contextualising it in two ways. First of all, what happened, and I'll come to the detail in a moment, I've got detailed references I want to make to Your Honour, but in substance what happened was two things. First of all, the delegate, at a point during the interview process, was indicating to Mr. Djokovic that his shift was about to come up. Yes. An interesting feature of the story when one might understand why it was that ultimately there was a reneging from the agreement to allow Mr. Djokovic reasonably until 8:30 to speak to Tennis Australia and so forth. But moreover, and what's even clearer, is that there was the articulation by both the delegate and a senior officer of what I can only describe as spurious rationales for why, in effect, it was said to be in Mr. Djokovic's interest to have the decision made without him getting assistance of others.
Well, this is part of the reason why I ask you about the format of Part 8, B and C and the manner in which these documents are progressively populated over the course of the night with all of the typed information, which is then given to the applicant and signed by the delegate and the date and time of it being given to him inserted. Because on a view, it almost, and I think particular caution is required here, but it has the quality of this ex post facto view. I'm coming in with a cancellation decision. It embodies in type form the basis on which I've made the decision. And then we have these people saying, look, getting in touch with your lawyers is really not going to help any of this, so why don't we just get it done?
And the proposition that Mr. Djokovic couldn't possibly obtain assistance from lawyers or Tennis Australia is manifestly erroneous. It would only be true if the delegate had a closed mind. Otherwise, there were obviously things that Tennis Australia, his lawyers and other people might have assisted, his agent might have assisted Mr. Djokovic with, either in persuading, in understanding how, despite all of the indications he'd received that he was okay to travel, in assisting him to understand why it might be that he's not, in assisting him to articulate why indeed a ground did not exist, but most obviously and clearly in assisting him to make arguments to the delegate that even if somehow it was open to the delegate to conclude that he did indeed pose a risk to the Australian community, that in all of the circumstances where he'd been led fairly to believe that he was okay to travel, and given who he was and what he was here for, the limited period of time to participate in the Australian Open, that given all of the circumstances, the discretion might indeed have been exercised not to cancel his visa, that these are all matters that he would have ably got assistance from his lawyers, from Tennis Australia, from the members of the legal profession in this room, but that opportunity was denied on the spurious basis that there was nothing possibly that anyone else could do that could possibly assist him, and it was in his interest that a decision be made, and then the lawyers might only help later to do what we're doing right now, which is to undo that very decision.
Can I ask you a question? I know and understand, I hope, why it is that you say remitter's not an issue, but nonetheless, is it of some relevance?
Sorry, guys. The connection seems to have dropped for the moment, but it should be back soon. Okay, we'll just wait for the connection to happen again. What's happened here is that there are too many people trying to actually join the actual Zoom session at the federal court, and that is now causing everybody to miss out on what's actually happening. So we'll just wait for that to resolve itself, and it will. And stick with us. Everybody's going to have the same problem. We'll just wait for those people who are clogging up the line to leave, and we'll be back.